Hello everyone, good evening. Welcome to Unacademy Judiciary YouTube channel. This is Aparna Bhat. As a part of solving Kerala question papers, as Kerala notification has been announced and prelims dates are approaching, I have already covered about 3 question papers so far. I have solved 2022 question paper, 2019 question paper and also 2020 question paper. I was about to solve 2017 question paper yesterday, but due to some reasons I couldn't conduct. But the same class I would be solving 2017 question paper on 2016. Okay, so I'll be solving that, and yes. So today we are going to solve 2016 question paper, right? Yes, so see here, one more thing. Unacademy offer is it has commenced from 2022 to 2028. Sorry, February 22nd to February 28th, and this will be helping you in your judiciary preparation of Target Judiciary 2023 and Target Judiciary 2024. This is one important thing which you can see. You can use the code Aparna Law. You can use this code Aparna Law, and you have a free All India Judiciary Scholarship test is there. This is for it's going to be conducted on March 5th, and at 12 p.m. You're going to have the examination. Then you have different batches: revision batch for Uttar Pradesh mains examination, which is available at a price of 22,959. Then linking batch, this is available at the for 6 months, and this is also available at the rate of 36,736. Then you are having Safalta 4.0 comprehensive batch. This is for the duration of 12 months. Then you have Chhattisgarh Judiciary Prelims mock test series. This is available only for ₹500, and totally 5 test schedules are there. Then you are having Punjab Judiciary 2023 mains test series. This is also available at ₹4,999, and 3 tests are available, as you can see. And you can use the code Aparna Law to again avail discount at about 20% discount. This is a valid code which you can use. And we have UP Judiciary test series as well. This is valid. This offer is valid only for ₹2,999, and it's only for first 100 subscribers. Okay. Then you are there's a new chance where you can win up to different rewards, and you can refer your friends, and due to this you can win some rewards. And also different YouTube channels are there: Judiciary Prep with Unacademy, Judiciary World, Unacademy Judiciary, and Unacademy Judiciary PCSJ. This also you will be having. So this is one thing. This is all regarding our different updates and different batches which are going to commence very shortly, and which have commenced recently. That is with respect to this. Then we are going to start with Kerala Judiciary question paper, that is 2016 question paper. So I'll be asking one by question, one by one, and you all can answer in the chat box, and also you can with short explanations I would be providing the answer. I think I can begin now. Okay. An instrument can be rectified under section 26 of the Specific Relief Act 1963 if the plaintiff pleads and proves that A. Through a mistake of the parties, the contract does not express the real intention. B. On account of coercion by the opposite party, the contract does not express the real intention. C. Through fraud or mutual mistake of the parties, the contract does not express the real intention. And D. Through misrepresentation of one of the parties, the contract does not express their real intention. So, what is the correct answer here? The first question regarding section 26, which is regarding the rectification. What is the answer here? It is nothing but C. C, that is through fraud or mutual mistake of the parties, the contract does not express their real intention. When these are the grounds, when fraud or mutual mistake is there, when these are the grounds, then under section 26 of the Specific Relief Act, they can claim rectification of the instrument. But it has to be, see, this is a 2016 question paper, so some questions could be before amendment, 2018 amendment is there. So please, if any discrepancies are there, that could be due to the amendment, like the pre-amendment question paper. That's because of that. Okay, next question. What do you mean by decree? Decree means a formal expression of an adjudication which so far regards the court expressing it conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit. Which of the following statements is untrue? A. It may be either preliminary or final. B. It includes the rejection of a plaint. C. It includes the determination of any question within section 144 CPC. And D. It includes an order of dismissal of a suit for default. Decree. Decree definition we can find it in section 2. And there are different deemed decrees and which are not held to be decree also, which is untrue, which is an untrue statement here. It is nothing but D. It includes an order of dismissal of a suit for default. Next one, third one. Plaintiff in a suit for specific performance of a contract has necessarily to plead and prove. See, now this plead is not there, it has been removed by 2018 amendment. So that's why so only prove is there. Please remember this is a 2016 question paper. So I am mentioning again and again, some discrepancies could be there because even in CRPC, even in Specific Relief Act, so many amendments have come. But the purpose of solving this question paper is the concepts, like how far the same questions have been repeating so far, on what concepts, and apart from some amendments, but other concepts are equally important. That's why it is very necessary to know what are the important questions, even though some amendments are there, but let's refer to that section when there is an amendment. So this is such a question where section 16 it got amended. So if anything skips, if I omit to say anything, please remind me that the particular thing, if you know about a particular amendment, please just remind me regarding that. Okay, what is this? He has to prove that this is not there, presently. He has performed and has always been ready and willing to perform. Section 16C, Specific Relief Act, very important. Okay, ready and willing to perform the essential terms of the contract. Next, if a defendant sets up a counter claim in a suit, the same may be proceeded with even if. So what if a counter claim is there? Plaintiff is there, defendant is there, defendant has set up a counter claim now. Can it be proceeded with? A. The suit by the plaintiff is stayed. B. The plaintiff discontinued the suit. C. The suit is dismissed. And D. Under all the circumstances mentioned above. Yes, it can be continued under order 8 rule 6. So even if the suit gets dismissed also, or it could be stayed, suit stayed, discontinued or dismissed also, but even the counter claim proceeds with. D is the correct answer. Next one, fifth question. Okay, this is a question under Kerala Rent Control Act, but still let's understand them, they are important. A tenant takes a building on lease in an area notified under the Kerala Buildings Lease and Rent Control Act 1965. He was prohibited from creating a sublease by the terms of the lease. Later he forms a partnership with another person and conducts the business. Landlord initiates proceedings under the Act for eviction on the reason of sublease. Decide. Action is not maintainable since there is no transfer of right or possession involved in this case. B. Action is maintainable because the lease deed prohibited the tenant from doing so. C. Action is maintainable because there is a transfer of a fraction of leasehold right involved. And D. Action is not maintainable because the tenant has not sublet the entire building. Yes, what is the answer here? It is 5A. Action is not maintainable since there is no transfer of right or possession involved in this case. Next one. Suit against the government or against a public officer in respect of any suit purporting to be done by such public officer in his official capacity shall be instituted after the expiry of dash of. Okay, so how many days notice has to be given in writing if you are filing a case against a government or a public officer who is doing in such capacity, who is doing his duty in such capacity? A 2 months, B 60 days, C 3 months and D 90 days. What's the correct answer? It is nothing but 2 months time has to be given. Okay, unless there is a very urgency or immediate some urgent cases are there, then you can dispense with the sending the notice. Otherwise, it is sufficient to give, it is mandatory to give 2 months notice. Otherwise, the suit will become premature suit. Next, seventh question. X promises to supervise on behalf of Y, a manufacturer of pickles, an illegal traffic in narcotic drugs. Y promises to pay X a salary of 1 lakh per month for supervising his business. The agreement is A. voidable at the instance of X, B. valid as one part of the contract is valid, C. void as the object of X promises and the consideration for Y's promise being a part unlawful, and D. voidable at the instance of Y. It is C, because this is a unlawful contract as per section 23 and it is partly unlawful. Then section 24 is applicable. Partly unlawful. See, pickles and also narcotic drugs, both are there. So when it can't be separated from each other, it's not severable, then the whole thing has to be considered to be illegal. Next one, 8th question. In a suit for permanent prohibition injunction, a question of title arose for consideration. Parties adduced evidence in respect of title as well. After trial, the suit was dismissed. Thereafter, the plaintiff filed a second suit for recovery of possession on the strength of title. The second suit is A. barred by res judicata, B. not barred by res judicata since the causes of action are different, C. barred by order 2 rule 2 CPC, D. not barred by res judicata as the two suits are of different nature. it is barred by res judicata. Okay, because here the question of title, whatever is there, even on the issues, res judicata is applicable. That's why this is the earlier suit whichever was decided, that is barred by res judicata. 9th question. Every person is competent to contract. Okay, so who is of the age of the majority according to the law which is subject, who is of sound mind, or who is not disqualified from contracting by any law to which he is subject. D. All of the above. What is the correct answer here? Section 11 speaks regarding the competency of the Indian Contract Act. So that's why all of the above, all these three categories of persons are considered to be persons who are competent to contract. 10th question. A court is not bound to grant a decree for specific performance of a contract merely because it is lawful to do so. This was earlier section 20. Okay, now please don't consider this because this has been substituted by substituted performance. Earlier this was named as discretion of the court, now amended as substituted performance of the contract. Okay. Next, 11th question. Which of the following statements of law is untrue? A decree holder under section 2(3) CPC means any person in whose favor a decree has been passed. B. Decree holder means any person in whose favor an order capable of execution has been made. C. Decree holder necessarily must be the plaintiff himself. And D. Decree holder can be a person who is not a party to the suit but in whose favor an order capable of execution has been made. Which is untrue? So the definition of decree holder says it so, that is section 2(2). Section 2(2) is for decree, section 2(3) is for decree holder. So decree holder is he is not this person, he need not be the plaintiff himself, but he could be a person in favor of whom an order capable of execution has been passed. So even such person also can be a decree holder. Next, 12th. A contract is not voidable because it was caused by a mistake as to any law in force in India. This statement is A. false, B. true, C. partly true and partly false, and D. none of the above. What is this? A contract is not voidable because this is true. Section 21 of Indian Contract Act. Next, 13th question. Civil courts have jurisdiction to try all suits of a civil nature. Okay, so this is a famous question statement under section 9 of CPC. But what is the continuation of this statement? Excepting the suits of which their cognizance is expressly barred. B. Excepting the suits of which their cognizance is impliedly barred. C. Excepting the suits of which their cognizance is either explicitly or impliedly barred. And D. Civil courts have jurisdiction to try all suits in spite of an express or implied bar. This is C. Excepting the suits of which their cognizance is either expressly or impliedly barred. Next, 14th question. A building contractor contracts with B to build a house for the latter in spite of making part payments for the work done. A commits a breach of contract and obtains a profit. Can B resign the contract and claim compensation from A for the breach? A, yes, since B rightfully resigned the contract, he is entitled to compensation for damage sustained. B, yes, he can resign the contract but cannot claim compensation. C, if B resigns the contract, it becomes an unlawful rescission for which he will be liable for damages. And D, B's remedy is only to compel A to complete the construction by taking appropriate legal action. What is the correct answer for question number 14? Yes, it is A. Under which question, which section? Under section 75 of Indian Contract Act. Yes, since B rightfully resigned the contract, he is entitled to compensation for damage sustained, and also section 73 also, section 73. Next question 15. A plaint was rejected under Order 7 Rule 11 CPC, finding that it did not disclose a cause of action. See, it did not disclose a cause of action. What is the remedy available to the aggrieved plaintiff? A, file a revision, B, file an appeal, C, file a restoration petition, and D, any one of the above. Rejection of the plaint is considered to be deemed decree. That's why it is appealable under section 96 of CPC. That's why you can file an appeal. B, file an appeal. Yes, Krishna, correct. You are answering rightly. Next one, 16th. Defaulting pawner's right to redeem lasts up to a time stipulated for payment of debt, be the time before actual sale of the goods pledged, C, the time before he receives a notice of sale of the goods, and D, he can redeem the goods even after sale if he pays any expenses which had arisen from his default. So, till when does defaulting pawner's right to redeem lasts? It is B, as per section 177 of Indian Contract Act. So, till the time before actual sale of the goods pledged, till then the right to redeem lasts. Next one, 17th question. In the absence of a contract or local law or usage to the contrary, a lease of immobile property for any purpose other than agricultural or manufacturing purpose shall be terminable on the part of either lessor or lessee by how many days of notice? A, 30 days, B, 60 days, C, 15 days, and D, 90 days. Yes, what is the answer here? This is a question under section 106 of Transfer of Property Act. Which is other than agricultural manufacturing purpose. It is 15 days notice. 106 subsection 1. 15 days notice is required. Next one, 18th question. Section 64 CPC says that where an attachment has been made, any private transfer or delivery of the property attached shall be void as against all claims enforceable under the attachment. Which of the following is an exception to the said rule? A, if the private transfer was pursuant to any contract entered into before the attachment. B, if the private transfer was made in pursuance of any contract made on the date of the attachment. C, if the private transfer was made in pursuance of any contract entered into and registered before the attachment. And D, if the private transfer was made in pursuance of a contract entered into immediately after the attachment. Section 64, which makes the attachment, the private transfer after attachment void, but it also provides an exception that if the private transfer was made earlier to the date of the attachment, then what will happen? Then it is C, if the private transfer was made in pursuance of any contract entered into and registered. Okay, if any contract was entered into and it was registered before the attachment, then that is an exception to the rule. Section 64, subsection 2 is the correct as an exception. Which of the following statement is untrue? Which is untrue? So, an agency is terminated by the principal revoking his authority. B. An agency is terminated by the agent renouncing the business of the agency. C. An agency is terminated by either the principal or agent dying or becoming unsound mind. And D. An agency is terminated when the principal is convicted for an offence. It says that D, an agency is terminated when the principal is convicted of an offence. This is the untrue statement. All are true statement under section 201 of Indian Contract Act. 20th question. In order to get the benefit of section 53A of the TP Act, what are the conditions to be satisfied? A. Transferee has in part performance of the contract taken possession of the property or any part thereof. B. The transferee being already in possession should not continue in possession in part performance of the contract. See, there must be a registered instrument of transfer, although the transfer has not been completed in the manner prescribed by the Registration Act of 1908. And D. All the above should exist. So, what is this? To get the benefit of section 53A. It is D. All the conditions have to be satisfied. Then 21st question. Fact that a civil court has no jurisdiction to try a suit shall be a bar to the exercise of its power to determine by whom or out of what property the costs are to be paid. The statement is A. False, B. True, C. Partly true and partly false, and D. None of the above. The statement is false as per section 35 CPC. Next one, 22nd question. A. The plaintiff in a suit for specific performance of a contract obtained a decree against B, the defendant. Later A failed to perform his obligations under the decree. What is the remedy open to B in such circumstances? A. He can approach the court with a separate suit seeking rescission of the contract. B. He can approach the court with an application in the same suit to have the contract rescinded. C. He can approach the competent court to execute the decree in order to rescind the contract. D. He has to file an appeal challenging the decree. Yes, what is the correct answer here? It is B. He can approach the court with an application in the same suit to have the contract rescinded. Next, 23rd question. Power to amend clerical or arithmetical mistakes in judgments, decrees or orders or errors arising therein from any accidental slip or omission may be corrected. This is a question under section 152, amendment of judgment, decree or order. So, when can this be corrected? At any time, within 1 year, C within 3 years, and D within 12 years. It is A, at any time. At any time it can be corrected. Next, 24th question. In a case, the plaintiff was able to seek a further relief than a mere declaration of title, but he intentionally omitted to seek the consequential relief. The suit was decreed. The decision of the court is. So without asking for a consequential relief, if the suit gets decreed, the decision of the court is A correct, B incorrect, C partly correct, and D the court has power to mold the relief by granting consequential relief. Because as per section 34, it is incorrect. Section 34, it says specific relief act declaration has to be mere it cannot be a mere declaration, but consequential relief, if it is there, then he should seek that in his pleadings also. Next, 25th, which one of the following need not be specifically pleaded in the pleadings? A. Misrepresentation, B. Fraud, C. Breach of trust, and D. Presumptions of law. Because the principles of pleadings, they say that plead fact, not the law. The presumptions also, even they need not be presumptions of law as per order 6 rule 13 CPC and others and all 12, they need not be specifically pleaded. Only presumptions of law have to be presumptions of law need not be specifically pleaded, but here they have to be pleaded. Next one, 26th question. In a suit for permanent prohibitory injunction, the court after trial court found that the plaintiff is entitled to the relief claimed and also found that the plaintiff is entitled to get damages. Although there was no plea raised in the plaint, the court granted a decree for injunction and damages in favor of the plaintiff. The decision is A. correct, as the court was dealing with an equitable jurisdiction, B. wrong, because no relief by way of damages should have been granted unless the plaintiff has claimed for such a relief, C. correct, because the plaintiff had every right to amend the suit and therefore even without an amendment it was rightly granted, D. wrong, because the plaintiff had no right to amend the plaint claiming damages at any point of time. It is B. wrong, because no relief by way of damages should have been granted. Okay, that is order 7 rule 7. B is the correct answer. Relief to be specifically pleaded. Relief specifically. Any material alteration of a negotiable instrument, if made by an endorsee, has the effect of A. discharging the endorser from all liabilities, B. binding himself with the liability, C. both the endorsee and endorser are discharged from the liability, and D. no legal effect at all. So what is the answer? It is A. discharging his endorser from all liabilities. 28th question. A suit by a person dispossessed from immovable property can be filed under section 6 of the Specific Relief Act 1963. A. after the expiry of 6 months from the date of dispossession, B. after the expiry of 1 year from the date of dispossession, C. before the expiry of 6 months from the date of dispossession, and D. before the expiry of 1 year from the date of dispossession. So question under section 6 of Specific Relief Act. C. before the expiry of 6 months from the date of dispossession. Next one, 29th question. When a promissory note, bill of exchange or check is transferred to any person so as to constitute the person the holder thereof, the instrument is said to be A. Endorsed in favor of the transferee, B. Negotiated, C. Effected payment in due course, and D. Accepted. What is it known as? It is known as negotiated. So section 14, it speaks regarding what is negotiation. Next question, 30th. A criminal court shall take cognizance of an offence under section 138 of NI Act. A. Upon complaint in writing by an aggrieved person. B. Upon a complaint in writing made by payee. C. Upon a complaint made by the payee or the holder in due course of the check. And D. Upon a complaint in writing made by the payee or the holder in due course of the check. It is D. Okay, as per section 142A. Upon complaint in writing made by the payee or the holder in due course of the check. Next one, 31st question. In section 3 of the TP Act, what do you mean by an instrument? It's a very common question. Instrument. Instrument is defined as a non-testamentary instrument. Okay, this question was, I think, asked in 2019 question paper. Which is testamentary and non-testamentary is there. Testamentary is relating to will, probate and all, whereas non-testamentary is relating to other than wills. Through succession it takes place. Wills and all upon death. This is non-testamentary instrument. Then 32nd question. Power to appoint a receiver in a suit should be invoked by the court. So when does this happen? A. Where it appears that the plaintiff has a prima facie case. B. Where it appears that the balance of convenience is in favor of appointing a receiver. And D. Where it appears to the court that it is just and convenient. And D. The court is satisfied that the defendant is trying to obstruct or delay the execution of decree. Here it is C, because not C, it is 40. Yes, when it is appearing for the court that it is just and convenient as per order 40 of CPC. Next, 33rd question. Which of the following statement is untrue as per section 6 of the Transfer of Property Act? Section 6 speaks regarding which properties are transferable and which properties are not transferable. Which is untrue here as per section 6? A mere right to sue cannot be transferred. B. An easement cannot be transferred apart from the dominant heritage. C. The chance of an heir apparent succeeding to estate cannot be transferred. D. The chance of a relation obtaining a legacy on the death of a kinsman cannot be transferred. So what is the fate of this? It is easement cannot be transferred apart from dominant heritage. Next one, 34th question. Under section 11(4) of Kerala Buildings Lease and Rent Control Act, the landlord can seek eviction of a tenant if he uses the building in such manner as to destroy its value, B. in such manner as to reduce its value or utility, B. in such manner as to destroy or reduce its value or utility, materially, D in such a manner as to destroy or reduce its value or utility materially and permanently. Yes, what is the answer? It is D. Okay, as per section 11. Yes, as per this section. Yes, please read this question. So, which is not an attachable property. Here, the attachment, Order 38 Rule 12, it speaks that agricultural property which is in the possession of judgment debtor, it cannot be attached. Okay, hence B is the correct answer. Please read the next question, 36th question. Okay, the acceptance of a gift. What is this? This is one of the important criteria, one of the important conditions in a gift. With respect to acceptance of a gift, what is true? It has to be made during the lifetime of the donor and while he is capable of giving. C is the correct answer. 37th question. Question under Kerala Buildings Lease and Rent Control Act. What is the correct answer here? It is A. He cannot be evicted except in accordance with the provisions of this Act. That is section 11(1). Next, please read the next question. 4 options are there. Question is regarding presumption of a negotiable instrument. It is not a presumption under this. The right answer is D. A lost promissory note, bill of exchange or check was duly stamped. This is the presumption. This not duly stamped, this is untrue. Okay, this is not true, but the presumption is that a lost promissory note, bill of exchange or check was duly stamped. Next question. Yes, Another question under Kerala. Okay, so this is right to recover possession arises within expiry of 1 year from the date of the instrument as per section 11 subsection 3. And the last question for civil law under part A. Which one is the incorrect statement? It is C. An injunction cannot be granted to prevent a breach of contract, performance of which could be specifically enforced under section 41. This is an incorrect statement. Next one, part B. Yes. So many questions are there. Please read them one by one. I am going to mark them correct. Mark the correct answers. It's also known as a deemed complaint. 41st question. But under which circumstance? When the report of a police officer after investigation is known as a deemed complaint. It is C. If it discloses a non-cognizable offence. So as per section 2D of CRPC definition. Next one, as per CRPC, complaint includes. So what do you mean by complaint? It is C. An allegation made, which could be either orally or also it could be in writing also to a magistrate. The same provision, section 2D of CRPC. Next, when does the trial commence? When do you say that trial commence? It is trial commences on the framing of charges. Next, 44th, when a person who is legally entitled to a property is gaining it by unlawful means. It is what is it? It is not a wrongful gain. Okay, under section 23 of IPC. Next one, 45th question. A person is said to do a thing fraudulently if he does that thing. Fraudulent, when do you say that it's fraudulent? Illegally, unlawfully, with intent to defraud, and the none of the above. section 25 of IPC. Then 46th question. In order to attract section 149 of CPC, a member of the unlawful assembly has to commit an offence: A. in furtherance of the common intention of all, B. in prosecution of the common object of that assembly, C. in cooperation with others, D. none of the above. If it has to attract section 149, then it is the proper word to say that it is B. It is in prosecution of the common object of that assembly. If it would be section 34, then in furtherance of common intention. Otherwise, section 149 in prosecution of the common object of that assembly. Okay. Next 47th. Yes, please read the question. What kind of offence is that? If two or more persons are fighting in a public place, and that too which is disturbing the public peace. They are said to have committed an offence of affray. A. Next 48th. In order to constitute an offence under section 279 IPC, a person has to drive any vehicle or ride. It is C. on any public way, that is section 279 IPC. Next one, 49 question. Whoever, to the annoyance of others, does an obscene act in any public place, he is committing an offence under which section? It is under section 294A regarding obscene acts and songs. Next 50th question. The offence of voluntary causing grievous hurt to deter a public servant from his duty is triable by A. the High Court, B. JMFC, C. Court of an Executive Magistrate, and D. the Court of Session. It is D, the Court of Session. Next, 51st. In order to constitute dowry death, the death of a woman should occur within few days of her marriage, few months of her marriage, C. 3 years of her marriage, D. 7 years of her marriage. Dowry death under section 304B IPC. You should commit within 7 years of her marriage. 52nd. In order to attract section 304A, death should be caused. How should the death be caused? By causing grievous hurt, by rash and negligent driving, C. by doing any rash and negligent act, by causing hurt. It is C. by doing any rash or negligent act. 53rd. Voluntary causing grievous hurt by use of acid invites an offence under section 324 IPC, 304 IPC, 326 IPC and 326A IPC. It is nothing but section 326A of IPC. 54th. Whoever assaults or uses criminal force to deter a public servant from the discharge of his duty commits an offence under C. section 353 of IPC. 55th. Please read the question. A man who follows a woman and attempts to contact her to foster personal interaction despite clear indication of disinterest by such woman. A. outrages her modesty, commits sexual assault, C. commits voyeurism, and D. commits stalking. It is D. commits stalking. 56th. For kidnapping a person from lawful guardianship, the victim should be under the age of 14 years, under 16 years, or under the age of 18 years. D. Under the age of 18 years. It is B, that is under section 361 of IPC. 57. A person who induces by deceitful means a woman of 20 years to go from her place to another place commits abduction, B. Kidnapping, C. Enticing, and D. Procuration. It is abduction, section 362 IPC. Next one, 58th. In a case wherein an accused who is represented by a pleader persistently disturbs the proceedings in court, the magistrate can dispense with his attendance and proceed with the trial in his absence, we cancel his bail and remand him to custody, C. pronounce judgment based on available evidence, and D. acquit him. It is A. Dispense with his attendance and proceed with the trial in his absence. Section 317 CRPC. Next one, 59th. Hello, Edward. 10. So, what is the 59th question? It is B. Okay, that's under section 317 subsection 2 CRPC. Next, 60. Trial culminates on the pronouncement of judgment, B. on examination of the accused, C. on examination of defense witnesses, and D. examination of all the witnesses. Trial culminates it's A. on the pronouncement of judgment. First, 319 CRPC. When can it be exercised? In the course of inquiry, at any stage, the course of any inquiry into a trial of an offence, and D. after trial. It is C. Next, 62nd question. Consent to withdraw from prosecution can be granted. That is at any time before the judgment is pronounced. Section 321 says it so. Withdraw from the prosecution. Next, 63rd. Offence of theft. When is it? It is confined to movable, immovable property, intellectual property, or any kind of property. It is confined to movable property, A. Then 64th question. No, theft is only for movable property. Next one, please read the question. For what kind do you require previous sanction of the central government? Intellectual property, how can you steal it? That could be infringement, but not theft. Not under IPC. So 64 is C for enquiry and trial under section 188 CRPC. Next, 65th question. Who is having no power to pass a conditional order of removal of nuisance under section 133? JMFC, district magistrate, subdivisional magistrate, and an executive magistrate specially empowered in that behalf by the state government. Yes, it is a judicial magistrate of the first class. He is not having any power of nuisance under section 133. Next, 66 question. The procedure to be followed under section 138 is that it is that of a summons case. 138. In a prosecution for defamation, cognizance can be taken sometimes cognizance can be taken only upon some person's complaint or only upon some police report. Some conditions are there. So what about this in the case of a defamation? It is A, only upon the complaint by some aggrieved persons. 68th. The explanation I will provide, okay, because it's 100 question I have to cover. It would like extend up to 2 hours if I go on providing, and also my voice is breaking. That's why I am not able to provide the explanations. Otherwise, I would have given. Then cognizance of an offence under section 376B IPC can be taken on a police report only upon a complaint by the wife against the husband, C suo moto by the court, and D in any of the above methods. See, cognizance can be taken under section 198 here because it's an offence against marriage. That's why section 198 CRPC. How? This is only upon a complaint by the wife against the husband. 198 provides that cognizance can be given, but this is in the case of offences against marriage, whereas this is an offence against marriage. That's why complaint can be given only by the aggrieved wife. 69th. For issuing a summons or warrant against the accused under section 204 CRPC, in the case of issuing the process, before you issue summons or warrant to the accused, what is the prerequisite? Then the filing of the list of prosecution witnesses is a precondition. That's a very first condition you have to meet. You have to file the list of witness, then you can issue process to the accused. Next, 70th question. When permission is granted to withdraw from prosecution, the court shall always discharge the accused. B, the court shall always acquit the accused. C, the court can opt to pass an order of discharge or acquittal. And D, the court shall discharge the accused when charge has not been framed and acquit the accused when charge has been framed. Again, this is a question under section 321, withdrawal from prosecution. So there are two circumstances: if the charge has not been framed and if the charge has been framed. The effects are different. If the charge has not been framed, then it will be discharged, otherwise it would acquit the accused. D. Then 71st question, compensation under section 357 3 of CRPC can be ordered in which circumstance? Like either with the fine, or as a form of part of sentence, like how, or without fine. (357) subsection 3 says regarding order to pay compensation. That's why C is the correct answer. When the court imposes a sentence of which fine does not form a part in such a case. So either you can award compensation or either you can award fine. 72nd question. The court which convicts and sentences an accused can suspend the sentence. It is the court which is convicting the accused. That court itself can suspend the sentence. But under which kind of offences? (72nd) it is A, where it's not more than 3 years. Okay, 72nd question is A is the correct answer. Then 73rd, whoever by deceiving any person fraudulently or dishonestly induces person so deceived to deliver any property to any person commits an offence of A. cheating, criminal breach of trust, C. theft, and D. misappropriation. This is the offence of cheating, 415 IPC. Okay, next 74th question. Okay, this is an order for proper custody under section 451. It can be passed in a case wherein the property is produced. A. before a criminal court during inquiry only, B. before a criminal court during inquiry or trial, C. before a criminal court during trial only, and D. before the police officer during investigation. This B. 452 is where after conviction, after that interim order. This is the nature of interim custody. This is permanent custody is given here. 452. Then 75th question. The case of a birth of a person during the continuance of a valid marriage between his mother and any man. The court may presume its legitimacy. It shall be conclusive proof of its legitimacy, and D. any one of the above. It is C. Section 112 of Indian Evidence Act. Proof of paternity, this is also known as proof of paternity. Next 76th question. Yes, please read this. 76th. Confession made to a police officer by a person accused of an offence. It is C. It shall not be proved if he was in police custody unless it made in the immediate presence of the magistrate. 26. Section 26 of Indian Evidence Act. Next, 77. In the case of certified copies of documents, duly certified, what do you mean by duly certified as per section 79? What is the evidentiary value of that? It is D, 77D. The court shall presume it to be genuine. As per section 79 only, regarding the genuineness of the certified copies. 78th. Presumption under section 90 of Indian Evidence Act is available to a document proved to be years old. Yes, exactly. As per section 90, right? If it was electronic document, it was 5-year-old. 79th. What are private documents? What are private documents? A. All documents other than public documents, section 75 of Indian Evidence Act. Next, 80th question. What shall not be permitted in cross examination? What type of questions or what is not permitted? It is D. Questions intended to insult or annoy. Such questions are not permitted under section 152 of Indian Evidence Act. So we have completed part B regarding criminal law, then all logical and constitution regarding questions. So let's quickly complete them. Part C, 20 more questions are there. In which case the Supreme Court declared that preamble is a part of the constitution. Golaknath case, Beriberi case, Keshwananda Bharati case, and D, all the above cases. Yes, it is Keshwananda Bharati case. How many parts are present in the Constitution of India? Originally, we have to say, because presently it is 25. Okay. Originally, how many parts were there? So, because key answers they were given as 22. This is a 2016 question paper, no? So, otherwise, this one 25 parts as per recent 2021. So, it depends like when you are answering. According to that, you can answer. 83rd question. In which case the Supreme Court held that the basic structure of the Constitution cannot be amended by the Parliament. Shankari Prasad, B. Golaknath, C. Minerva Mills, and D. Keshwananda Bharati. And again it is here. It is the Keshwananda Bharati case where basic structure cannot be amended by the Parliament. Next one, 84th question. Which of the following two words were added in chronological order to the preamble through the 42nd Amendment? It is B. Socialist, secular. B is the correct answer. 85th question. The institution of Ombudsman was first introduced in New Zealand, Norway, Finland and Sweden. This was introduced in Sweden. UGC of India is a statutory body, constitutional body, neither statutory nor constitutional, and D, advisory body. UGC, University Grants Commission. It is enacted by way of UGC Act. That's why it is statutory body. A. UGC Act of 1956. 87th question. The Election Commission of India has a quasi judicial power, C, regulatory power, B, advisory power and D, constitutional power. It is 7th question. It's the quasi judicial power. 88th question. Which one is not a fundamental duty? To safeguard public property, to vote in public elections, to develop the scientific temper, and D, to abide by the constitution and respect its ideals. All fundamental duties have been given under section 51B, 51A. So B is the wrong answer. It means it is not a fundamental duty to vote in public elections. Okay, which one of the following writs literally means what is your authority? Habeas corpus, B, certiorari, C, quo warranto and D, prohibition. What is the authority means? It is, yes, it is quo warranto. Yes, Edward, correct. Okay. 90th question. Okay, complete this article. No person shall be deprived of his life or dash liberty except according to procedure established by law. So, what kind of liberty should not be deprived of as per Article 21? It is B, personal liberty. 91st question. Which of the following amendments was the most comprehensive amendment of the Constitution? A, 52nd, B, 44th, C, 68th and D, 42nd. Yes, Aarti, correct. Aarti and Edward. What about 91st question? Yeah, it is the most elaborated comprehensive amendment, that is the 42nd amendment. 92nd question. Which of the article deals with the amendment of the Constitution? Article 374, 356, 368 and none of the above. It is C, Article 368. Next one, 93rd. In India, money bill is certified by A, Prime Minister, B, Finance Minister, C, Speaker and D, Vice President. So money bill should be certified by Speaker as per Article 110 of Constitution. Yes, Stafford, Stenley Edward. 94th, maximum strength of Lok Sabha is. It is 550, 475, 470 and 552 as per Article 81 81 of the Constitution. It is D 552. Then 95th question. The Election Commission is responsible for the conduct of the elections to a Parliament, State Legislature, the Office of the President and the Vice President, and the all the above. What is this? For the conduct of the elections of all of the above. Article 324. Then these are all logical based questions. Next, from 96 onwards, 5 questions are there. CBI gets a complaint that an officer has demanded bribe from the complainant. A. CBI shall wait for further complaints against that particular officer for verifying the genuineness of the complainant. B. CBI shall take immediate necessary steps to catch the officer red-handed. C. CBI shall forward the complaint to the concerned station house officer. And D. CBI shall summon the officer and interrogate him for verifying the genuineness of the complaint. What is it? 96 question. It is B. CBI shall take immediate necessary steps to catch the officer red-handed. 97th question. A particular product of a company which was running very good in the market has drastically gone down. So what is the assumption? If it was going good, running good. A. The company shall make a proper study of the rival products in the market. B. The company shall immediately reduce the price of the product. C. The company shall immediately improve the quality of the product. And D. Company shall ignore it and concentrate on other products. It is A. Company shall make a proper study of the rival products in the market. Next one, 98th question. You come to know that one of your friends is gossiping about you. So you will confront him and question about his attitude. You will complain to his superiors or family members about it. You will ignore it and you will stop contacting him. Just general questions. These are all general questions, general behavior. So what would you do about this? It is, you will ignore it. See. Yes. Next, one of your colleagues has problems at work. A. You will ignore his or her problems. B. You will complain about it to your superiors. C. You will not interfere in the matter unless your help is sought for. And D. You will help him or her to solve the problems even if your intervention is not requested for. Ninety-ninth question. Would you help him or not? With intervention or without intervention? It is D. You will help him or her solve the problem even if your intervention is not requested for. So that is how you help the social the structure, how you behave. And the last one, which one of the following statement is correct? The Supreme Court of India has plenary powers. B. All the high courts in India have plenary powers. And C. All the courts in India have plenary powers. And D. No court in India has plenary powers. Okay, it is A. Supreme Court of India has the plenary powers under Article 142 of Constitution of India. So far we have completed 100 questions in 2016 question paper. And yesterday I was supposed to complete 2017, but I couldn't due to some personal reasons. I could not take this class. But this is on 26th, that is Sunday, same time 9 p.m. Okay, so it has unlimited powers in that sense, plenary. Okay, Supreme Court. Yeah. So I was saying about 1 minute. So we have come to the end of this session, and already I mentioned in the beginning of this class that there is a new free All India Judiciary Scholarship test is there. Okay, so yeah, thank you. No, I'm really sorry I couldn't provide a explanation. Usually I provide, but today I was my voice is not supporting me. So if I speak too much, then again tomorrow I am not be able to speak. So that's why I'm taking in a very slow manner. Okay, so tomorrow also we have the same time. So by that I'll recover and I'll try to explain all the possible points. Do attend at 9 p.m. And yeah, this was about I was mentioning about free All India Judiciary Scholarship test, which is going to be conducted on March 5th at 12 p.m. So you can enroll into this, and this is the offer which is going to extend till 28th February 22nd to 28th. You can use my code Aparna Law for enrolling into this particular different batches. Different batches have also been announced. This is my code for unlocking special class also. This is my code, and also availing discount also can avail this code. Yes, Aarti, thank you. Good night. So good night all of you. And again we are having about 4 I have completed. 3 more question papers are there. But when if we move on to the previous question papers, many how I saw section 20 of Specific Relief Act, that's completely amended, but the same old question will be getting. Some discrepancies will be there, but the concepts they're stagnant, that will never change. So that's why if we solve about 7 question papers or 8 question papers, it would be of some help for our examination. So whatever amendments it could be, but still let's try to solve them along with all the amendments or changes, new updates. Okay, yes. So thank you all of you for joining, and initially I have explained about how the different batches are conducted. There are 3 months batch, 6 months batch is there, 12 months batch, 3 months batch is for Uttar Pradesh, then linking batch for RJs and GJs is there. Safalta 4.0 comprehensive batch. So in the beginning of the class only I have explained this. Again, I am reminding all of you, if you want to join, you can join all these any of these batches, and many test series are there. Chhattisgarh test series, Punjab Judiciary, then Uttar Pradesh Judiciary. So this is a new offer. This is priced at only rupees 2,999, and this offer is valid for only first 100 subscribers. So how much ever quickly you enroll into this, you will be eligible for this price. So thank you all of you, and you also have the chance to win different rewards if you refer your friends to join a particular course or particular minimum 1 month plus course or iconic course. You are having the chance, you can avail even that benefit. And these are all our channels, different YouTube channels, and this is an Unacademy Telegram channel. You can also join my Telegram channel at Unacademy Judiciary Aparna Bhat. Yes, so this was all about the session. So thank you, take care, bye bye, good night, and do not forget to like, comment, share and subscribe to this YouTube channel.